Hi everyone, welcome to this webinar brought to you by Bursa Malaysia and managed by LifeChamp. My name is Stella and I will be the moderator for today's session. Our our title today is Passing on Prosperity: Estate Planning for CDS Accounts. Have you ever thought about what happens to your asset in your CDS account when you are no longer around? It is a conversation many of us tend to avoid, but taking time to plan ahead can bring invaluable peace of mind for you and your loved one. So today, we are honored to have one Irda Rina to share with you on how to effectively incorporate your CDS account into your estate planning. Before we proceed, allow me to do a short disclaimer. Please be reminded that everything that shared in this session is mainly for educational purpose only, and by no way that we are providing you advice to buy or sell any securities. You are 100% liable if you make any investment decision. Now, allow me to briefly introduce our speaker, and she is not other than Puan Ida Rina. Currently, Wan Ida Rina serves as the Chief Executive Officer and Islamic Financial Advisor Representative at TSI Wealth Planners Sendirian Berhad, an Islamic financial advisory firm approved by Bank Negara Malaysia. She also holds the position of Financial Planner Representative at Philip Wealth Planners Sendirian Berhad and acts as a Senior Islamic Legacy Planner. Additionally, she is the subject matter expert in Zakat and estate planning for the Malaysian Financial Planning Council (MFPC), and also she trained on estate planning modules for MZ Associate in collaboration with IBFIM and FPAM. So with that being said, let's welcome Puan Ida to the floor.
Thank you very much, Stella.
Okay.
Okay, let me share the slide first. Okay. Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh, and a very good evening to everyone. First of all, I would like to thanks to Bursa Malaysia and also LifeChamp for inviting me to deliver this topic in tonight's webinar. And also, I would like to welcome everyone for joining tonight. And tonight, I'm going to share with you the topic passing on prosperity estate planning for CDS account. Tonight, after this session, participants should be able to understand the assets. That means which one is categorized as assets and the subject matter for the estate administration purpose. So is it the share counter, is it the stocks unit, or how about the CDS accounts? And then the second one, we are going to discuss the issues and reality in estate administration, specifically for stocks traders or investors, because stocks are unique and it differs from other assets such as property, vehicles, bank accounts. So we will discuss on the issues and reality, particularly when involving stocks we traded in Bursa Malaysia. And after understand the issues and reality, then only finally we will discuss about the estate planning solutions to ensure smooth transfer of your stocks or Bursa shares to the loved ones. Okay. So, to understand the assets, upon death, we will be leaving various kinds of assets. So not only our house, but there are many other types of assets that one could possibly have, such as takaful or insurance for non-Muslim, businesses, vehicles, savings, as well as investment instruments. So the chart here only depicts the physical and registered assets in Malaysia. By right, it shall also include digital assets and other types of intangible assets, such as trademarks, copyrights, and royalties. So that means this chart is not limited. After we die, this is examples of asset that we will be leaving to our family members, to our next of kin, or for Muslim, to faraid heirs. So for our focus for estate planning session tonight, estate planning lesson tonight, is just about one kind of assets, one kind of investment instrument, that is the shares. The shares, specifically shares we traded in Bursa Malaysia. And all these assets, as you can see in the slides here, they have their own evidence or proof of ownership. That means the document that shows who is the registered owner of the assets. For example, the proof of ownership of a land, we have to refer to the land title. To prove ownership of a car, for example, we have to refer to the vehicle ownership certificate. So to prove ownership of a company, we have to refer to the SSM's form 24. To prove ownership of bank accounts, we have to refer to our bank statement. Therefore, how to prove ownership of Bursa share counters that we purchase via trading accounts, which we maintain with various investment brokers. So it is important to understand how to identify the ownership of our share, which we maintain at various investment brokers. So let's take a look at this example. This is land title. So for the land title is the document registered at the land office to prove ownership of a property. So for example, in the case of bank account, we refer to the bank statement. Then only we know how much is the balance we left, and then who is the owner of the account in the bank statement. But for the landed property, we have to refer to the land title. So the portion of ownership in the land title for the land is in the form of fractions. This is the example. 1/1 bahagian, 1/1 portion. Therefore, when we make application for estate administration, we have to mention the title number, the lot number, the district, the district where the assets is located as the asset identity. And this fraction is to show the portion that is owned by the deceased, and it become the subject to the estate. That means this portion, how much is what is the fraction that the deceased own, that's determine the ownership of the deceased. So how about stocks that we trade in Bursa? Which particulars should we use to show our ownership? Is it the share counter? But the share counter might change from time to time, especially for active traders. We like to buy and sell counters in a short period. So that means every month the CDS statement could be different. Is it the current value? But the share current value also change daily. But actually it can be used to determine how much is the estate value as at current. So estate value is still important to identify the jurisdiction in which application of estate administration to be made. So for stocks in Bursa, the document that you need as a proof of your ownership is the CDS statement. So it is available in Bursa Anywhere apps. Nowadays, you can download the CDS statements in Bursa Anywhere apps. And from the CDS statements, the unique identity of the assets is the CDS account number. So if you have CDS accounts in various brokers, that means let's say if you have 3 accounts in different brokers, so you have 3 CDS account number. So this is the account number that you need that will become the identity of your estate. So this account number have to be listed in your application for letter administration for the purpose of estate administration. So from the CDS account, the CDS statement, the unique identity of asset is the CDS account number. That means if you have stocks maintained at 3 investment brokers, therefore you should have 3 CDS accounts, and all the statements are available in Bursa Anywhere apps. So your CDS account number is your asset identity, and your portion of ownership for each counter is determined by the number of share units stated in the CDS account. So this is your ownership, portion of ownership in the form of share units. As we know, in Malaysia, the minimum purchase of shares is 100 units for one lot. So this is the portion of ownership. So that's why the stock, the bursa stock is kind of unique assets because it's based on units, and also the identity is based on the CDS account number. So since we already knew which one is the asset identity and which one is the portion of ownership, now let's discuss on the issues and reality in estate administration for this bursa shares, this CDS account. So when someone dies, all assets is considered frozen. Frozen here means the asset cannot be transferred, cannot be transacted, and cannot be withdrawn. That means it's not literally frozen, or it's frozen and not move. The market value still changes, but it simply means that once the asset is frozen, once you die, the asset is frozen. That means it cannot be transferred, cannot be transacted, cannot be withdrawn, because the authorized person to perform such transaction, that is the asset owner, has died. So the asset still there in the CDS account. That means the value still change based on the market price, but nobody can perform any transaction, cannot transfer, and cannot withdraw on behalf of the account owner. It just like a frozen asset is locked in the vault. So therefore, we need a key to unlock the assets before the assets could be used to settle debts and before it could be passed to the beneficiaries or faraid heirs for Muslim. So looking at this chart, I make this table to segregate. This is the chart that summarizes what will happen to the things that we left upon our death. So once we die, upon death, besides our family, we also will be leaving our debts and also few categories of assets, which I segregated into 3 categories. So the first one is the frozen assets, which is registered in specific institution, specific financial institution, but without nomination. And the second category, I categorize as unfrozen assets. So this is why I call as unfrozen assets, because these assets have nomination. That means in the event of a death, this asset can be withdrawn by the nominee, the nominee that we name in the nomination form. And the final category is the unfrozen assets but unregistered. That means there is no specific institution that maintain the registration of these assets. For example, jewelries, watch, luxury handbags, paintings, our collectibles. So they is considered as unfrozen. That means anyone can just simply take it or move it or can sell it. But of course, there's a trust issue there. So for shares, it falls under this category of frozen assets because bursa shares have is registered under the CDS account with the investment brokers, but bursa shares have no nomination. It have no nomination. That means it's unlike EPF or takaful or insurance or tabung haji. Bursa shares have no nomination at the moment. So what should we do with these kind of assets? Before this asset could be liquidated or withdrawn or could be unfreezed, therefore the family members would require letter of representation. So you just focus in this table under the frozen asset because we focus on the shares only. So to unlock these shares, specifically shares maintained and shares traded in bursa, the faraid heirs or the beneficiaries would require letter of representation. And this letter of representation depends on whether the deceased died testate or died intestate. So if the deceased dies with an appointment of executor, so let's say the deceased during his lifetime, he made an appointment of executor in the will or in wasiat. Therefore, the executor can, therefore the deceased is considered as died testate. Therefore, the executor can apply grant of probate from the civil high court. But Yeah, most of us still a lot of people in Malaysia did not make such appointment of executor during lifetime. Therefore, upon death, it seems like the law considered this deceased does not trust anyone. So that's why he doesn't appoint any executor. But actually, the reality is most of people doesn't make appointment of executor during lifetime, doesn't make what will or wasiat because just have no time or maybe because of lack of awareness. So if there is no appointment of executor made by the deceased, therefore, the family members have to apply for the letter of administration because the deceased is considered as died intestate. So letter of administration, the purpose of letter administration is to appoint an administrator who is entrusted to managing all the estate administration matters on behalf of the deceased assets. So the grant of probate or the letter of registration issued by the relevant jurisdiction, then only can use all the assets to settle the burial expenses, the debts owed to religion, the debts owed to institutions, the debts owed to human, and also to dispose of will, especially for Muslims. So we have a wasiat, which is subject to maximum of 1/3 to non-heirs. And finally, then only can be distributed to the legal heirs according to faraid or based on the will for non-Muslim. So this is the flow before the assets could be passed to the beneficiaries. Okay, so that means this example. So once grant of probate or letter of administration has been obtained, then only can unlock and unfreeze all the assets, including the CDS account. And then only after perform all the debt settlement, so all these assets can be passed to the beneficiaries. So it is the responsibility of the family members of the beneficiaries to ensure to unfreeze the asset, to ensure smooth transfer, and to distribute the asset in permissible, efficient, and effective manner. So, but the question is, where to administer the asset? Where to go? Where is the first place should the heirs, the beneficiary go, and who to administer the asset, and how to obtain the letter of administration or grant of probate? How? So this is the issues that we're facing right now because to obtain the letter of administration is not something that we do every day. It's not something that we do every day. So maybe every one of us maybe don't have such experience, don't have any experience of handling estate administration, or probably maybe only have once in a lifetime or 2 times because it's not things that we do every day. So to answer the question, if someone dies without a will and no executor, therefore the objective is to appoint the administrator. So the function of administrator here is to have the power to to liquidate the frozen assets of the deceased. So in Malaysia, there are in Semenanjung Malaysia, in West Malaysia, in Semenanjung Malaysia, in Peninsular Malaysia, there are 3 jurisdictions where to apply the letter administration. And this 3 jurisdiction depends on the type of assets that the deceased have and also the value of assets that the deceased have. So for example, if the deceased only leaving movable assets only, for example, vehicles or shares in private limited company, macam sediak berhad. And then for example, also bursa shares, the CDS account, but the total is not more than 600,000. Therefore, the family members can apply a letter of administration from Amanah Raya. So Amanah Raya will become the administrator. But if the deceased have immovable assets, but under the new law, under the new amendment of small estate distribution amendment in 2022, before this, the deceased need to have it compulsory for the deceased to have immovable assets before the family members could administer the estates in the small estate units. But with the amendment, with the recent amendment, which effective 1st July 2024, if the deceased only have movable assets only, so the family members can also apply the letter administration from small estates unit as long as the total asset value less than 5 million. So, a small estate unit also one of the jurisdiction that can issue the letter administration and appoint the administrator. So the administrator here can be any of the family members, normally para heirs, can also be a mana raya, and can also be State Islamic Religious Council under the new amendment, Majlis Agama Islam Negeri. And finally, if the deceased have either movable only or movable with immovable assets, but more than 600,000 if movable only, or more than 5 million, or actually civil court have the power to issue letter administration if the total assets more than 50,000. Therefore, the family members can, but normally if less than 5 million, the family members would prefer to administer the asset at the small estates unit because of the cost factor. But of course, in order to be for quick solution, actually civil high court is the fastest way to obtain the letter administration. So civil high court have the power to issue letter administration, even though for the assets more than 50,000. But in under normal circumstances, normally people will go to civil high court after when the assets above 5 million. So civil high court can issue the letter administration or distribution order for the property. So with this, the challenges is in terms of time. Of course, it will be time consuming and also cost and also energy, because it involves multiple steps which is unfamiliar to the family members. So it is important to appoint the administrator who is capable to manage the assets, who is trusted and also can give commitment to the estate administration works. So it will be another issue whether can the administrator carry his or her as a responsibility, because the process will take a long time before the asset could be released to the beneficiaries, to the fara'i heirs, to the legal beneficiaries. So this involve another trust issues, whether the administrator can be trusted. So that especially for individual administrator, because he has to carry the burden of handling the assets, the estates, and also settling all the debts. Of course, have to take to settle the debts, have to take the assets left by the deceased. But the administrator have to carry the responsibilities, have to ensure the procedure follow as per what is required by the law, required by the religion, especially for Muslim. So, and another issue is there are circumstances whereby the family did not know what are all other assets being kept by the deceased. So it's all yeah, because sometimes people being too, I mean, don't like to share to someone else, don't want to share with the family members, even don't want to share with the spouse what are the assets that they have. So it will cause trouble to the family members to determine what are the assets left by the deceased. So this is the example asset known to the family, maybe only about 10%, but actually there are still a lot of assets hidden which is not have been disclosed by the deceased to the family members. So this is another challenge, because this will further lengthen the process, will further delay the process, will further trouble the family members in terms of estate administration. I have one case which I would to share my experience of handling. This is considered my first case administering do the estate administration on behalf of my client. The application was made in the small estate, pesaka kecil. So this deceased is deceased have a lot of bank accounts, have properties, have vehicles. So finally, after about 1 years, then only we got the letter of administration. The delay was because of documentation. Even though the deceased kept all the most of the documents in the file, but still there are certain documents that he didn't keep and only known to several family members only. So the family already got the letter of administration, which I helped to make such application at the small estate. But after got the letter of administration, suddenly they received a letter from one company. So that means this deceased have shares purchased from this share counter. So they received a letter saying that there is a dividend payment made by this share counter to the deceased account. Then only they realize that, oh, that means this deceased have a share investment, have a stocks, but they couldn't find where is the CDS statement. That means the deceased didn't keep any CDS statement and didn't keep any record about the share investment in Bursa. But they know that the deceased have shares because of the check that they received via the letter from the specific share counter, this company. So what to do? They have to find out to make another resubmission, another application to the small estate unit to obtain a letter administration for the assets that they just found out. So they have to go through another series of process. So that's the example of how the estate administration process can be further delayed just because you not disclose everything to your family members. And another issue is, of course, unable to find documents. Because of unable to find documents, that's why your family members not aware of certain assets that you have. And also, even though your family members aware that you have certain assets, but if you didn't keep proper documentation physically, that will further trouble your family members. Because to apply for letter administration, especially in Amanah Raya or at small estate, they need a proof. They need the document to as a proof or evidence that this deceased have this asset at certain institutions. So that's why documents are also important as a proof. Unless if they're at the High Court, maybe they are a little bit flexible in terms of the documentation. And those old days, just to recap, those old days, the Bursa Malaysia, the CDS account statement, all mailed to our house, to our doorsteps, to the mailbox. We will receive the CDS account statements physically via letters. But nowadays, everything is in digital platform. So all online in the Bursa Anywhere apps. So just imagine when let's say you kick the bucket or you pass away, your handphone may be everywhere. So for example, if the person, let's say a share trader dies, maybe in an accident, the handphone crash. So and everything is in the handphone. All the digital, the apps. Nowadays, we keep many apps in our handphones and everything in there. So this is another issue that we are facing right now because everything is in digitalized. So it is best for any asset that you maintain digitally, you better print out your CDS account statements, at least one for each broker. So for example, in this picture, you can see I have three investment brokers, but one this with maybe investment is no longer active because this account was non-syariah, so I close it. Because I work in my bank before, so I close it already. Now I have these two CDS account statement. So by right, I have to print this document, at least one CDS statement, and keep in the file so that if I pass away, my family members and my executor can have the documents to apply for the grant of probate because I already made the will and appointment of executor. So it is important and crucial for us to have the physical we have the paper, even though nowadays we go paperless and digital. Nowadays, because all the application to the jurisdiction that I shared just now, the three jurisdiction, the Amanah Raya or small estate or high court, all still have to use paper to prove to approve the ownership in the specific assets. And another challenges is in terms of the procedures. Like I said just now, this estate administration is not something that you do every day. It's not something that you do every day. So of course, most of people not familiar on how to do the estate administration, where to go, how to apply, what is the procedure, what is the document, how to fill up the form. So this is another challenges to the family members. Of course, the easiest way is to appoint someone who is have experience or someone who provides such service, such service such as trustee or lawyer or independent consultant to help to administer the assets. But of course, to do that, you need a cost, you need a budget to appoint someone else, the third party, to handle on your behalf. And this is the example of estate administration for Bursa shares. So, for example, upon a demise, the family have a discussion on how to start administer, who should do the work, and then start gathering information, what are the assets and debts left by the deceased, and also have to collect all the documents, collect and arrange all the documents for the purpose of submission. And then normally the longest part would be this part, especially if the deceased did not keep proper record. So this will take so long to find the documents. And then after that, make submission to either Amanah Raya or small estates unit or civil high court. So for just now, if the person dies intestate, that means there is no appointment of executor. Therefore, the family members have to make application made application of letter administration from the three jurisdiction just now. But if the deceased have made an appointment of executor during his lifetime, the executor can apply grant or probate from the civil high court. So submit all the documents to the jurisdiction, and then of course for small estate units and civil high court, they will call the for small estate unit, they will call the family members. For high court, they will call the administrator or the executor for hearing. But for Amanah Raya, for application at Amanah Raya does not have hearing because Amanah Raya itself become the administrator. So upon complete of this process, letter administration will be issued. So that say if the if the deceased have executor, that means grant of probate will be issued. Then with this letter administration can only be presented to the Bursa Malaysia, particularly at the Central Depository, Bursa Central Depository, to present the LA so that to liquidate the shares. Liquidate means the share units will be released to the administrator's CDS account. So that means the administrator also need to have CDS account, need to open CDS account at the brokers, at the investment brokers. So the shares will be released in terms of units and also the counters, based on the counters, the units and also the counters to the administrator CDS account. So it is the responsibility of the administrator to distribute the assets to the beneficiaries. But the question is in distribution in terms of what? In terms of value. If you want to distribute in terms of value, that means you have to sell all the shares. If all the beneficiaries agrees to sell, then only distribute in terms of the value to the beneficiaries. If the beneficiaries not agree to sell the shares, probably it's from the blue chip counter, for example. So maybe and then the beneficiaries maybe trader like to trade shares. So maybe he doesn't want to sell the share because of the market condition, for example. So that means they have to transfer in terms of number of units. But they trigger another problem. how to distribute, how to calculate the distribution of the units. So for example, in para 8, let's say the deceased only have one son and one daughter. Therefore, the faraid portion will be 2/3 for son and 1/3 for the daughter. But the deceased living, let's say in a counter ABC for 10,000 units. So how to divide? So if we divide the units based on the faraid fractions, therefore it will trigger the odd lots. So in shares, in stock market, odd lots is difficult to be traded. Nobody wants to buy odd lots because remember the minimum units to be purchased for Bursa shares is 100 units. Therefore, if we separate it based on the faraid numbers, therefore it will trigger these odd lots. That means the son will get 6667 of share counter ABC. Let's say this is a blue chip counter and it's very valuable. And then the daughter will get this portion. Therefore, it becomes odd lots already. And in certain circumstances, it also happen, especially if the estate administration is being done at the small estate, for example. So if the distribution in the if the distribution order is stated there based on the fraction, for example, like this 2/3 or 1/3, then it will be problem because of course if you present the distribution order to the Bursa Central Depository or to the brokers to make such to liquidate to withdraw the asset, they will transfer based on the distribution order, which is according to the units. Then it will be trouble. So of course, to us maybe it will be easier if all the units are maintained by the administrator, and the administrator sell off the shares and distribute in terms of cash. But another issue is whether all the beneficiaries or the faraid members they agree to sell the shares, and if they want to sell the shares, at what point each of shares should be sold. Maybe they want to choose any date. Depends on the market condition or that. So this could lead to further lengthen of the process. Another issues and reality for CDS account is the first one, a proxy account, especially for those who want to apply for IPO, initial public offerings. They want to apply for IPOs. They want to, in order to get higher chances to win the ballots. So they like to use other individuals' name, proxy names to apply for IPO. But actually, they are the one who contribute to the to buy the shares, but they use someone else's name. So that they have two chances. They submit under their name, and they submit under their spouse name, for example. So let's say the spouse win the the ballots. So that means the shares, even though contributed by you, so but the shares are under the someone else's name. So that's another issues um, in the stocks, in shares, in Bursa shares, because of the proxy accounts. It means maintain in the CDS accounts under the name of someone else. But in fact, you are the one who contributed for the capital to buy the shares. And then the second issue is delisted shares. So for example, if these deceased have many shares in his CDS account, and probably some of the shares are already delisted. Even though it's delisted, it's still there in the statement, but it's just that cannot be traded because it's inactive. Some counters inactive, delisted, but the units are still there. So this also is still can be passed to the faraid heirs, to the beneficiaries, but cannot be traded. That means no value on that shares. But for the brokers, they will still transfer the shares. And then finally is in terms of Sharia classification. So, for example, because in a year there are two times Bursa will come out with the with the list of Sharia counters, and which one is Sharia reclassified as the non-Sharia, or non-Sharia counters reclassified as Sharia. So this is another areas that for Muslim have to take into consideration, especially when you see the list of counters, there is non-Sharia counters Therefore, it is a responsibility for the administrator, the members to do the cleansing of the Syariah counter. So for cleansing, that means have to liquidate the shares and also have to calculate from which point become non-Syariah, and have to compare with the purchase price. That's another issue. And then if there is a non-Sharia amount, therefore this amount have to be surrendered to be given to the Baitul Mal for the purpose of cleansing. So that's another issues in terms of shares. So what are the solutions? Because we already know the issues, the reality for this share counter, for these stocks we maintain in CDS accounts. What are the solutions that we could prepare right now to ensure that smooth transfer of our assets, specifically the shares? So I divided the estate planning solution into three. The first one, in terms of administration. The purpose of administration is we want to plan so that we can ensure the smooth and efficient transfer of the shares from our account to the beneficiary account. And then the second one is we need to plan in terms of distribution, especially if you have specific concern. You want to give your share to specific beneficiaries, but in efficient manner, effectively. And the final one, of course, when you do the estate planning, you plan about the administration, you plan about the distribution, but you need to have the budget, because this budget is really crucial to finance the cost of administration, because everything need a cost. To apply for letter registration need a cost. Of course, there's nothing free in this world. Of course, need to pay. It's either you prepare the budget upfront during your lifetime so that it will be easier for your family members, or your family members have to use your own estates to fund for the estate administration. So in terms of administration, what should you do? So the first thing, the most basic things is you have to make appointment of executor via wasiat for Muslim, Islamic will writing. So for non-Muslim, you can just appoint executor via will. So you can make appointment of executor. Of course, under the law, there are two types of executor, either individual or trust company, which is established under the Trust Company Act 1949. So, of course, there are pros and cons. If you appoint individual as the executor, yes, probably less cost. But whether the individual executor can really handle the responsibility, can handle the task, can be trusted, and how long he will live, and whether maybe the executor that you appoint predeceased you, that means dies before you. So it is best to have a trust company to become the executor, because they have certain powers under the Trust Companies Act 1949. And of course, they not easily close their business operation. And also, because of that, of course, there are certain costs. And also, they will be automatically waived from the need to provide the surety bonds if application made in the High Court. So because of that, of course, it's the best to appoint a trust company. But with that, you also need to have budget, because the trust company will have certain charges when administer your assets. But once you appoint this trust company executor, you don't have to worry anymore, because they will settle from A to Z, until the assets successfully pass to the beneficiaries. And then not only appoint the executor, you should do the list of assets, maintain list of assets. You have to list down all your debts and assets so that it will be easier for your family members to know which are your assets, to locate the documents, and also it will be easier for the executor. And finally, print and keep proper documents, because these documents are important for the purpose of estate administration. And the second one, in terms of distribution. So let's say your family member, let's say you have specific concern. For example, the case of the proxy account just now. So the proxy have to do hibah of the shares back to the rightful owner. So the purpose of the planning in terms of the distribution is to give to specific beneficiaries effectively. So in terms of distribution, you can plan to do hibah, or you can also, for husband and wife, can also do jointly acquired assets, because there is this instrument in estate planning. Certain trustees have offered this kind of instrument, jointly acquired asset, but the most popular will be hibah. Otherwise, you can also put this asset under wasiat. But if you put under wasiat, first wasiat is to be given to the non-faraid heirs, but it's subject to maximum one third. If you mention in the wasiat to give to the faraid members, it's still subject to faraid. Therefore, if you have specific concern, you want to give your share counter, for example, maybe then you can plan in terms of proper distribution of units. So you can plan maybe 10,000 units of share counter ABC to to your son, and then another 10,000 unit. Maybe you can separate 5,000 to your son, 5,000 to your daughter, with the same counter. So at least you can plan to mitigate the issues of the odd lots just now. So this is another solutions in terms of distribution. And also about the proxy account just now. So those proxy can give back their shares to the rightful owner via the hibah. And finally, of course, the budgets. So because the budget is also crucial, no matter whether you make appointment of executor or not, no matter you appoint individual executor or trustee company as the executor, you still need to have budget to ensure that all your assets will be administered by the family members, and they have they have budget to administer your assets, because everything will involve cost. To make application also involve cost. It's just that whether the cost is huge or small. So the purpose of to prepare in terms of budget is to finance the cost administration. How to prepare the budget? You can use the asset with nomination of executor. For example, takaful, you can make nomination in takaful under the executor. You can make executor appointment under takaful, or via insurance or EPF, you can make a nomination, so that the nominee can withdraw from the account and can use to fund the estate administration. And also can also do, if you have living trust, you can also create trust. So in the living trust, you can also specify that part of the money upon my demise, you can upon my death, you can use part of the money to fund the estate administration purpose, to fund the hibah transfer, for example. And also the final one, you can use your own liquid assets, because yes, this estate administration, the budget have to come from your planning. So that means if use the liquid asset which is also frozen, that means still the family members have to advance their money to perform the estate administration before the frozen assets can be liquidated. Then only they can claim back. So this is some of the examples that you can prepare in terms. So remember, in terms of estate planning solutions, have to prepare. The first thing is in terms of the administration, because the purpose the purpose is to ensure that, because administration is important, because most of us only think about how to distribute the asset, how to give to the loved one, how to give to this person, how not to give to this person. So most of us will think like that. But the most important thing is in terms of administration, how to ensure the beneficiaries will get what they should get. So even though you don't have specific concern, even though you are okay to give based on faraid calculation, still there is still in need of the planning in terms of administration, because how to ensure that your faraid beneficiaries, your faraid members will get in accordance to their faraid portion. How to ensure that your assets being used to settle your debts. So Yeah, if to talk about experience, there are many occasions whereby always the spouse have to settle the deceased debts, whereby other family members, for example, parents, the family members, parents or siblings, just waiting for their shares, for their portion. But the debts, always the spouse have to pay. But by right, any debts should be used, should be settled by using the assets that the deceased left. These three important sections in terms of administration, gift, and also budget. Three things that you need to prepare. So for administration, for Muslim, you can make wasiat and appoint executor. And nowadays, we also have digital wasiat whereby you can list all your assets, including digital assets. And also, you also have to prepare if you have specific concern. For example, you have adopted child or you want to give shares to specific beneficiaries, then might as well you plan via hibah. And if you want to give specific portion to the beneficiary according to the correct portion in the uh, in the in the form of minimum 100 units, for example. So you can plan via hibah or jointly acquired property. And finally, in terms of budget, you need to have budget, because without budget, no matter whether you do appointment of executor or not, it will further trouble your family members, because everything need cost. Before I end up my session, remember, you have to plan ahead, plan now. So just leave no room for uncertainties. You shouldn't leave for any uncertainties. If not, if you didn't make any plan, then the law will decide for you. So you decide now, do the plan, appoint your executor, make your own decision who should be the executor, make your own decision, make a list, the asset list, and make your own decision on how you would like the asset to be distributed, how you should get the portion. You plan now, because if you not doing the planning now, then the law or someone else will decide for you. So that's all my sharing. I will pass to Stella for the Q&A session. Thank you.
Alright, thank you Puan Ida for her wonderful sharing. Now, do you guys have any question? Please type your question in the Q&A box, okay? So, okay, for the first question, can we nominate a nominee to inherit our shares like in appointing a nominee in life insurance policy or EPF?
Okay. For the CDS account, currently there is no nomination for CDS account. So right now, the only thing that we can do is planning via will, wasiat. For Muslim, can do hibah. So currently there is no nomination for CDS account. It's not like EPF. I'm not sure if in future the investment brokers want to do such nomination, then it will be good.
Okay, so for the second question, how about amanah saham or unit trust or bond?
Okay. So for Amanah Saham, let's say Amanah Saham ASMB, the one that is instrument by Amanah Saham Nasional Berhad, right? ASMB. ASMB have no nomination, but they have product that is called Hibah Amanah. So it's two different things, because nomination is something that you nominate a person. It's just that in terms of distribution, it is stated whether this nominee, we nominate this person as the executor or beneficiary to that specific account. But ASMB don't have nomination, but they have this product called Hibah Amanah ASMB, whereby the client, the account holder, can make this hibah amanah via the ASMB counter. So they can name the beneficiary and give the portion in terms of percentage, how to give to the beneficiary. So for ASMB account is a bit different from the stock market, from the bursa shares, because bursa shares in the CDS account, and then the asset is in the form of units for the specific counter. But for ASB, normally it will be in terms of value. So it will be, even though there's a market, but the distribution is in terms of value. That means it will be easier to be administered. That means it will be easier for to be distributed to the either to Farad members, or you can also make such hibah amanah under ASMB to give to the specific beneficiaries. For bonds also don't have a nomination, and unit trust, some of the unit trust management company have a nomination. So if you have a unit trust maintained at the unit trust any unit trust management company, you need to check and you can make a nomination. You can ask them and make such nomination.
Okay, we hope we have answered your question. So the following question is, what is the fees charged by the trustee or administrator, and does this include the fees to transfer to the beneficiary?
Okay. The trustee charged by the trust the trust I mean the administration fee, the state administration fee charged by the trustee different among the trustees. Even though in the law it stated that the trustee can charge up to maximum 5% over the assets, but different trustee have different charge, and normally they not charge up to 5%. So I cannot mention specific trustee. Some of the trustee charge 1.8% for the first 1 million, and then 1% for the next 10 million. So different trustee will have different pricing structure. And some of the trustee charge 2% for the whole estates. Some of the trustee also charge, they start at 5%, but for the first 25,000, and then 4% for the next 235,000, and then 3% for the next 250,000, and then 2% for the next 500,000, and then 1% for the remaining. So each trustee will have different structure of fees, and this fees is basically is only their charges. It's not inclusive of third party charges or miscellaneous charges. For example, if they appoint a runner or they have to make a land search, or if the broker charge certain fee for withdrawal, that is not included under the structure charged by the fees charged by the trustee.
Okay, we hope we have answered your question. The next question is, what if the shares are on pledge as margin facility? What will happen to the transfer?
Okay, so if there is a margin facility, that means, of course, because it's considered debts, that means have to settle first. So that one is another issue. That of course have to, if there is a certain debts, that means have to issue the debts. Then only maybe probably have to liquidate the shares. But still, if there is, even though after liquidate the debt, the shares, but still have a portion to cover, that means have to use other assets to pay for the shortfall. But in terms of administration, in terms of the details on the administration, how the procedure, that one I still don't have information about the margin financing, how it should be, how's the exact process. But of course, because margin financing is also considered as debt, so probably have to liquidate the shares to pay back the financing. But if there is shortfall, then only have to use other fund to cover.
Okay, so for the next question, what happened to the shares in the CDS account if the account holder passed away without any named beneficiary? For example, he has no spouse, children, or next of kin. Is there any solution like unclaimed money where the shares can be transferred to a government agency?
Okay. For of course, they need someone to start to administer no matter what assets. As far as I'm concerned, shares is not subject to the unclaimed money. But for bank accounts, yes, go to unclaimed money. For tabung haji also it won't go to the unclaimed money because they have specific rules and for the tabung haji. But for the shares, I believe it won't go to unclaimed money. It will stay in the CDS account. But it of course need someone to start administer the account or assets for the deceased. But another issues is if the deceased have no beneficiary. For example, Muslim convert, Muslim convert. So that means they have no beneficiary, no family members who is Muslim. So the beneficiary, the final beneficiary is Baitul Mal for Muslim. For non-Muslim, the final beneficiary is the government. If you read at the Distribution Act 1958, the government. So this is another issue. Who going to start to administer the assets? That means maybe the friend have to initiate, have to approach trustee to start administer the assets. Therefore, the final beneficiary, if for someone who don't have beneficiary for Muslim, the final beneficiary will be Baitul Mal. But for non-Muslim, the final beneficiary will be the government. But still need someone to initiate the process of estate administration.
Okay, we hope we have answered your question. The following question is, assuming administrator has all the legal rights, can he or she transfer to their CDS account before redistributing if needed?
Sorry again.
Assuming the administrator has all the legal rights,
Uh-huh.
can he or she transfers to their CDS account before redistributing if need to be?
Okay. Actually, the shares will be transferred to their CDS account because they already got the power via the letter administration. So in the letter administration, it will stated there the name of the administrator. Therefore, only the administrator have the power to withdraw the assets. So the Bursa Central Depository via the broker will release the shares to the administrator's CDS account. So the administrator have to keep in the CDS account. Of course, trust is important in this matter. So when the beneficiaries everyone already decided how to distribute the assets, then the administrator have to make the transfer of shares to the beneficiaries. So that's why it's important to appoint executor, especially for the trust company. So they will once they got the grant of probate or the administration, they will keep in the qualifier account until the beneficiary make a decision whether they want to sell off the shares and just get the in terms of value, or they want in the form of the units. So then only the administrator or the executor will transfer to the respective beneficiary accounts.
Okay, so for the following question, for a joint bank FD and savings account with either one to sign, if one person pass away, will another joint owner have the issue in withdrawal?
Okay, this depends on the bank actually. Based on my experience, it depends on the bank. By right, for the condition that is either want to sign, of course another person can can withdraw, or maybe they have she has password, so she can withdraw. But it depends on the bank as well. Some of the bank might freeze the account. So when freeze the account, of course they will need the letter of administration. So when the banks need the letter administration in terms of distribution, normally if this is what I got from the trustee feedback from the trustee, they will check the survivorship clause. So if there is a survivorship clause, of course the balance will go to the to another account owner. But if there is no survivorship clause, therefore half of the portion will go to the estate. That means to the faraid beneficiary, or according for the non-Muslim based on a will or distribution act.
Alright, we hope we have answered your question. So the next question is, unclaimed shares in the CDS account, will it be transferred to unclaimed money? How does it take for Busa to transfer to unclaimed money?
As far as I am concerned, no, it won't be transferred to unclaimed money. But sorry if I'm wrong, correct me if I'm wrong. But as far as I'm concerned, for CDS account, no, because unclaimed money only involve bank accounts. But for bursa, it will go to unclaimed money because for bank accounts, yes, have if until 7 years there is no transaction, then it will straight away go to unclaimed monies. For shares, it will remain there until claim has been made.
Right. So the next question is, are there any changes to the Distribution Act 1958 amended in 1997 for non-Muslim recently?
Not that I aware of because I'm more focused on the Muslim side. But I know about the Distribution Act. That means, yeah, is of course in terms of the distribution, the first one is the family members, and then the next one will go to the siblings, uncles, and finally the government. But I don't have such information whether there is any amendments on the Distribution Act. Because that one is specifically for non-Muslim, right?
Okay, so for the next question is, if the shares are all residing in nominee account with, for example, Rakuten, is the
Mm-hmm.
transfer process similar with CDS account where the nominee's account number is to be stated in the will?
Because Rakuten is different because Rakuten is like digital or online, right? It's not really like the investment or other investment brokers. So probably for Rakuten, it will be a different procedure. But usually for all other assets maintained in Malaysia, of course, it will need letter administration. But Rakuten is a bit different because it is used online platform. So maybe a slightly different procedure from the shares maintained at the investment brokers. So usually most any digital platform will still require the document, the letter of representation, the letter of administration or the grant of probate because still that's the document that testify that the administrator have the power to withdraw. But in terms of the process, how Rakuten will release it, that one I'm not so sure. But I just know that Rakuten is like online platform is kind of different a little bit from the one that we have in the investment brokers, the maintain investment brokers.
Right. So for the next question, for those shares transferred to the administrator CTS will be a separate CTS account, for example, trust, or will be the same CTS account if the administrator has its own CTS account containing his own investment.
Mhm. Okay. Yes, of course, it's something that is crucial if transfer to his own CDS account, right? Uh, uh, Normally, I think they have to open a separate CDS account for the purpose of estate administration. Previously, for like for a bank account, previously it will go straight away to their personal account. But nowadays, bank also will ask to open separate accounts. So I believe for the CDS account, it should be the same. That means the administrator have to open other accounts which is separate from their own shares. So then only he can we will have proper governance, proper monitoring before it could be transferred to the beneficiary. But for the like for trustee, it's clear cut. That means they will open CDS account based on the name of the deceased. For example, because of course trustee have many clients, they maintain accounts for many deceased. So they will open separate account for each of the deceased. So for example, they will open CDS account under the name of like ABC trustee in estate of Irda Rina binti Qamar Bahrain. So it will have another account ABC trustee in estate of Ahmad bin Ali, for example. So they have separate account for different clients. But for individual administrator, uh, they should open a separate account so that it won't mix up with their own shares. If not, of course, they will face claims by the beneficiaries if they mix up together with the shares.
Okay, we hope we have answered your question. For the next question, how will the inheritance be managed if the deceased is a Muslim and the children are not Muslim?
Okay. Um, under the Islamic law, only Muslim can inherit from Muslims deceased. Therefore, if you have family members, if our non-Muslim friends have family members that is convert to Muslim, it's best to advise them to make wasiat to give, because yeah, sometimes maybe this person already they convert to Muslim, but they still have parents which is non-Muslim. Of course, they still love their parents. So maybe they want to give certain portion to their parents, but under the Islamic law, non-Muslim cannot inherit from Muslim. So, for example, this Muslim convert, they still have this person has still have parents, but if this Muslim convert dies, the Muslim parents won't get anything because of under Islamic law, the non-Muslim cannot inherit from Muslim. But non-Muslim can still get something from this Muslim person if he makes wasiat, which is maximum one third of his estate, or via hibah. So that's why if you know anyone, if you are our non-Muslim friend, if you know anyone that is already convert to Muslim, and they still have parents or family members which they still love, they want to give something. So it is crucial for them to do wasiat or hibah. Uh, and so if let's say this Muslim convert, let's say he doesn't have family members that is Muslim, maybe bachelor, or maybe he only have spouse Muslim. That means still have portion that is not go to anyone, but finally will go to the Baitul Mal. In certain cases, Baitul Mal will surrender a certain amount to the non-Muslim family members. But the non-Muslim, let's say there is a certain portion go to the Baitul Mal, the non-Muslim family members have to make claim from the Baitul Mal. So basically Baitul Mal is releasing their portion, their faraid portion to the non-Muslim family members if there is a claim. But under the Islamic law, the non-Muslim will not inherit from the Muslim. Therefore, the Muslim have to make a proper estate planning to give some of the portion to the non-Muslim family members.
Okay, thank you, Puan Ida, for answering the
Welcome.
question. So the next question is, how long does it take to apply and obtain an LA for movable asset, immovable asset? Do we need to engage a lawyer to apply for an LA? How much would be the cost?
Okay. It is different between the jurisdictions. If Amanah Raya, upon submission of documents, they will process. They will contact me after 6 months. And so that's the time period that they usually convey or tell to the applicants lah. So it will take at least 6 months and above. But based on my experience, it's more than that. And then for small estates, one, you submit the complete document. If there is a property in your assets, minimum 3 months, is a minimum at least 3 months to get to be called for the hearing bicara kuasa. Minimum 3 months, but it can be more than that. So after you have the hearing at the small estate, it will take about another 1 month minimum to get the data administration. 1 month or can be more. After you get the data administration, then only you can present it to the relevant institutions. So basically, the fastest is, of course, 4 months, 5 months, 6 months. But in reality, based on my experience, it's more than that. That one is at the small estate, because the issues is maybe they have many cases. Different small estate have different timeline based on my experience. Some of them will call for court hearing after 6 months. Some of them call for hearing after 3 months. Some of them call for hearing after 1 year. Especially during COVID, because during COVID, these offices always is closed for quite long. So of course there are many backlog for them to settle. And let's say if high court is the fastest way based on my experience. Once you make filing at the high court, you make filing in this morning, so by the evening you will get the dates already for the court hearing. So the dates normally will happen, will be done, will be held about 1 week or 2 weeks or 3 weeks upon the date of the filing. And then after the court hearing, maybe within 2 weeks or 3 weeks, you will get the letter administration. So at high court, probably 3 months, 4 months can get the letter administration already. So for high court, usually you need to appoint lawyer. Even though actually you can as a as a beneficiary, you can apply by yourself, but you can submit by yourself. But the problem is we normal people don't know how to prepare the affidavit, the originating summons. So of course you need the lawyer to prepare the document. But for application at Abana Raya and also small estate, that will be easier because they just use forms, so can just fill up the forms as long as you fill up correctly. But for high court, it is advisable to appoint lawyer because we normal people won't familiar with the terms in the document.
Okay, so for the next question, are joint banks account also frozen? For example, can the joint bank account still be accessed by the surviving individual after the other person whose name is on the account has passed away?
Okay. So this is similar like the question just now about the condition either want to sign. Right. So for the joint account, if it's only if the condition is both to sign, of course, that means the surviving party cannot do anything to the account. But if either want to sign, that means it depends on the institution. So different institution might have different treatment. So for account, for bank account, so they will have different treatments. That means they still need for the LA. That means cannot simply withdraw. So it depends on the institution.
Okay, so for the next question, can I transfer my shares to my spouse CDS account just like we transfer to our own CDS account? Can do it via Bursa anyway?
Via bursa anyway, I don't think so, but you can do it via the brokers. You can perform the transfer. Via bursa anyway, I don't think you can transfer the account because you need to liaise with your investment broker. Then the investment broker can do the transfer. You can transfer doing the outright transfer during your lifetime to another party, transfer the shares. So you have to liaise with the brokers, specific brokers. It's not via the Bursa Anywhere. Bursa Anywhere is just for maintaining the record to get the statements, all that. But for transfer of shares, for trading of shares, you still need to liaise with the specific investment broker.
Okay, we hope we have answered your question. So for the next question, can I designate two people as beneficiaries for one CDS account? How to divide? For example, first person inherits 70% of the share value, while the second person inherits only 30% of the value.
Okay. In the will, you can state like that. In the will or hibah document, you can state that kind of distribution in terms of percentage. But in terms of the mechanism of transfer, it is responsibility of um, the administrator to distribute. That means if based on percentage, if we use the percentage and times to the number of units, it will become the odd number, odd lots. So if odd lots, of course, is not marketable. Therefore, if it is best for the beneficiary to agree to sell the shares so that it can get in terms of cash, then it will be easier to distribute based on the percentage rather than to distribute in terms of the units because of the odd lots just now.
Okay. So for the following question, what happened to the shares in the Mumu account that does not shown in the CDS account?
Momo account. Momo account. Okay, I'm not aware about the Momo account. This is the first time I heard about it, but Momo account. Okay, so something interesting. It's not appear in the CDS account. Okay, that one. I don't have answer for that. I'm so sorry. But it's good to explore. Okay, I will find the answer for it. Momo account.
Uh,
I think MOO. Is it?
MOO. Yeah.
MOMO. Okay. That
If
means I
I
heard about it, but I'm not sure what is it. That means
or
I heard about it, but I'm not sure what is it. Yeah.
if I'm not remember wrong, Mumu
Mhm.
account is a nominee account.
Nominee account.
Yeah, it's a nominee
Okay.
account.
Nominee account, but it's not in CDS statement. It's CDS account. Okay. Uh, okay. I'm sorry, I don't have answer for that because the one that I have knowledge of is only in terms of CDS account. But it's a good question for me to find out the answer. Register with Bursa. Oh, okay, okay. Okay, Mazlan. So that means a lot of things I have to learn some more.
Okay, so for the next question, list of stock for estate planning purpose is never exhausting and
Mhm.
ever changing. How do we actually write in details in the will?
Okay. Yes, that's another issues because in the will, yeah, because we won't update our will every day, right? So normally, even though we make the will and then we keep with the trustee or the provider, we still need to have a record at our house in our home to that list down and the record that we maintain and keep update from time to time. And I also would like to share with you, which recently there is uh, on a digital wasiat. So they also actually they establish this digital estate planning, digital wasiat to mitigate the issues of updating the list of assets. So because if you do the physical wasiat, it's not easy for you to keep on updating the list of assets. The solution is you keep your own record. That means you have to print or maybe in your diary. But recently, there is like a digital wasiat, which is introduced by, so I don't know whether I should share or not. It's called sampul.co. So sampul.co, you can actually amend the list in real time. Amend the list every day. So that it will be easier for you to maintain this list of asset and update the debts and assets that you have. So this is new in the industry.
Okay, so for the next question, if I name the nomination in my insurance and EPF accounts and I made a will the nomination remain valid? Also, can I allocate cash in my salam in my will?
Okay. Nomination in the EPF or insurance, right? Both have different rules in terms of the administration and also the distribution. Like for EPF, the nomination has different treatment for Muslim and non-Muslim. That means for Muslim members, the nomination is only for the appointment of executor under the EPF. But for non-Muslim members, the nominee become the beneficiary for the non-Muslim EPF members. So if let's say you make a will for Muslim who make a will, the still it won't override the power of the nominee to withdraw the fund in the EPF account. Same like insurance. Anything in the will, it will not let's say you appoint executor in the will, it will not override the power of the nominee as you made in the insurance policy or EPF. That means only the nominee have the right to withdraw. But in terms of distribution, that means whether the nominee is it are they beneficiary or only the executor. that one will depends on whether you are Muslim or non-Muslim. And then depends because for EPF, like I said just now, if you're Muslim, you're just executor. That means in terms of distribution, you have to refer back to wasiat. If there is a wasiat to the non-para AS wanted, so you have to follow. The nominee have to follow because he just executor. But for non-Muslim, he become the beneficiary. That means it's his rights. For insurance, it's a different treatment because insurance is based on based on Financial Services Act 2013. Therefore, it depends on the nomination, whether the nomination is made to spouse, children, and also for those bachelor to the parents. So it will have different kind of treatment in terms of distribution. So in other way, if in the insurance, if it makes the nomination to the spouse or children, then they will become trust beneficiaries. Therefore, that's become theirs, the insurance claims, because the we cannot override anything in the insurance in the Financial Services Act 2013.
Alright, we hope we have answered your question. So since we do not have much time left, we will just take one or two more questions. Okay, so the next question is, do the inheritance tax that going to be introduced apply to the capital market of Malaysia?
Okay, there's a rumors that inheritance tax will be implemented in Malaysia, but so far it's just a rumors. So we have to wait until the budget. We have to wait until the PMX present the budget. So hopefully there is no inheritance tax because we have been enjoying without the tax as for now. So that's just a rumors. But I cannot say because this is just my opinion, right? So maybe there is a inheritance tax for capital, but maybe not. But it's just a rumors that there will be inheritance tax. But of course, as a rakyat, hopefully no lah. As a rakyat and also have assets, hopefully there's no such inheritance tax lah.
Okay, last question.
Mm-hmm.
If I say whatever asset not specifically mentioned in my will, which mean I don't list down the CDS account, can Amanah Raya transfer my shares to my beneficiary?
If Amanah Raya not aware about the asset, they won't transfer because let's say because Amanah Raya will only act if there is application made for the administration. That means there's no other party who will automatically transfer without the consent or without any submission of claims or without any application of estate administration. That's why sometimes people thought the frozen asset until 90 billion is because Amanah Raya didn't liquidate, but it's not like that. It still depends on the family members. They are the one who have to initiate the process of estate administration. So if they submit to Amanah Raya, and Amanah Raya will refer to the list that they submit. If there is a CDS account, then only Amanah Raya will administer it. If it's not in the list, then they won't find, because in Malaysia there is no center that keep the records of all what are the assets that we have. Currently, we don't have such center that keep records what asset that we own. So it based on the initiative of the family members to find the information, and it based on our initiative as the someone who is still alive to make a proper documentation and record.
Okay, so maybe we can try one more question.
Okay.
Can the shares be sold in the market on the day when the person die?
Uh, because the application of the administration will take time. Unless if you have the password. Okay. Unless if the deceased share the password of the trading account to the family members, then the family members execute the transfer. Of course, this is wrong lah, because by right you shouldn't perform transfer on behalf of someone else. So unless you have the password, then of course you can still sell off the shares and get the money, but the money can be credited to the this account. But talk about in terms of legality under the law, of course it will need some times to apply for the letter of administration or grant of probate. So it is not possible to make the transaction within the same day, unless if someone have the password and do it for on behalf of the deceased. But it's wrong lah, by right. Stella? Thank you very much also to everyone. I'm sorry if there is any questions that I couldn't answer. That means I have to learn more about this, especially about the Momo account. I heard about it, but I have yet to explore about the account. So it's interesting to learn more. So okay, I pass to Stella. Thank you very much to every one of you.
Okay. So, wait a moment. Yeah. Okay. So thank you, Wan Ida, for answering the question.
Welcome. Thank you
So,
very much.
okay, we do hope everyone here did get something out of the session today. Okay, so due to time constraint, if your question haven't been answered yet, no worries. Okay, you can contact Wan Ida, and we will share her contact information on the last slide.